So okay, we have Katarzyna Rakowska from Inicjatywa Pracownicza and also Warsaw University. Great that you are here, and the floor is yours.
Thank you. Today I want to talk about the right to strike on a little bit of historical context and changes of the right to strike, both in international context and in local context, on the example of Poland. But I think that a lot of you will relate because especially Lithuania, but also other Central and Eastern European countries, strike law is very similar, as we heard in the previous presentation. And I will start with a little bit of theory because I'm trying to put the right to strike and law in historical context and the context of capitalism and changes of capitalism. So forgive me for a little bit of theory at the beginning. I'm starting with the famous quotation or unionist saying from that originated in the USA, that without the right to strike, we don't have the right to collective bargaining because it's just collective begging if we cannot stop our work. But at this point, I also want to mention that though I am working with law and I'm studying law as sociologist, I'm not a big law lover, and I don't think that unions should always rely on law and legal actions. So for today, I will, as I said, I will put the right to strike in some historical context, as well as we will try to talk about strike laws in our countries, Central and Eastern European countries, as well as I will show you some examples from Poland about how we are trying to maneuver in this very harsh law. But starting with some theory, what already Agnes started yesterday, I'm trying to look at law through the theory of the cycles of capital. Sometimes they're called waves, especially in American school. In Europe, they are called cycles usually. So the theory or the historical school of analysis of capitalism through its crisis and through its accumulation. And as we saw yesterday, the mode of production and the produce, the type of accumulation, the ways of accumulation change in history. But also what changes in history is the whole institutional and regulative system. So during the history of capitalism, how we produce things, how workforce is employed and how it's used, what kind of wages and what part of capital they get, how financial system is organized. Also, what is the law? Law on strikes, law on trade unions, but also other social laws, and how can we unionize legally, institutionally? That changes with the changing regimes of accumulation or waves of accumulation of capital. And another concept I am using that we were talking about yesterday is the concept of fixes of capital. And what it means, it's derived from Harvey and Beverly Silver. What it means that capital is both fixed and it fixes the modes of production on the way, or the ways of accumulation. When we look, for example, at producing something, capital is fixed in factory. It cannot move in one day. It's fixed in the machinery, in the plastic or metal for this produce, so it stays in one place. But in order to fight competition, for example, also it uses different fixes. It tries to fix the surroundings by moving to another country. So it's called spatial fix. Or with changing the ways the capital employs people, or produce, or how machines work with innovation. That's technological fix. And how I look at law is what kind of legal or institutional fix capital uses to help reproduce itself with either restricting workers or restricting our right to strike or our right to associate. So I didn't put 2008 here that Agnes talked about, but as we will see today, especially after 2008, so since the crisis, the attack on the right to strike on the international level and in Poland is very, very strong. So I've been looking through those 4 phases, but actually the 5th phase after the crisis is the most vivid, as we will see. So when we are talking about changes of the right to strike in the centers and semi-peripheries, so in usually Europe, United States, is that, of course, in the 19th century, the right to strike was non-existent, and what unions did they were fighting for the strike, and strike was criminalized back in 19th century. So as for institutional surrounding of the associations and strikes, there was none. So we had like pure, let's say, class struggle without any special laws, but any activity and strikes were considered to be terrorist and to be against states. So the strikes and workers' union were in the realm of criminal law, not workers' law. Then between the wars period, some institutionalization began, sorry, the hardest word for me in English, and we started to see legalization of trade unions and the right to strike, but with this legalization, we need to remember there goes restrictions. So every regulation restricts our rights. And at that period, we also saw first court cases on the right to strike with huge development of laissez-fairism ideology, saying that any strike laws and laws to associate actually restrict capital and restrict business, and those court cases were often won by the capital, by the business, because on the grounds of laissez-fairism. So also the legal institutions of the state, like courts, which we have to remember for the rest of this presentation, they are affected by ideology and by the prevailing ideology, not only the mode of production or the movement of capital. So ideology and how we perceive, freedom of association and the right to strike is affected in different modes of regulation. And then we had, of course, for this, with what we call concessions to labor. So the capital agreed for some concessions to labor, agreed to accommodate workers' unions in state regulations, in state decisions, especially in Europe, Western Europe, but also in state socialism, trade unions became very, maybe not powerful, but active in the sphere of the state. And this is the period where the right to strike became international, legalized internationally, and this is what we call the era of human rights. And the right to strike became human right on the international level. And then in what we call post-Fordism, since the 70s crisis, we can see that on international level and on country levels, the right to strike as a human right and as a mechanism that is within the state rules started to be dissembled, and we are facing more and more different types of ban of strikes, what I call the race to the bottom. So this is just to remind what were the 40s regulations, social regulations on the strikes. Especially the strike was integrated into international human rights. These two, ILO Convention and the Universal Declaration of Human Rights, this is only the right to associate, and from the right to association is derived, like, by logic, the right to strike, and in European social charters and Convention of Economic Social Rights, the right to strike is explicit. And of course, we've seen huge waves of strikes, especially in Western Europe, through collective bargaining on the sectoral and country level, because we need to remember when we talk about collective agreement coverage in Western Europe, that it was always supported by strikes. It's not like France, Belgium, Netherlands, good government came thinking we love workers and they should have collective agreements. It's that with every negotiation, every period of negotiation of the collective agreements, every 4 years, every 5 years, depending on the country, is also faced either with strike threat or with strikes. 1 day, 2 day strikes, but with strikes. So this was the period of really using the strike to develop country regulations. And what happened in post-40s is first, until the 2008 crisis, was dismantling the union power. Through modes of production, through globalization, unions started to lose members because of closing of factories, mines, so structural changes. And that kind of stripped workers of the right to strike, because less and less workers started to belong to trade unions when we think about Western Europe or United States. I will go to Central and Eastern Europe in a bit. So structural changes happen, but law didn't kind of affect, the law didn't change at that period. It was also because of the agreement between employers and employees, union side in the International Labour Organization, that until there is communism in Europe, we won't kind of move the right to strike. There was agreement that there is Soviet bloc, threat of communism on Europe, so we won't touch that law because then the communists will rise and they may threat our democratic peace in the West. So only after the Soviet bloc collapsed, only after that, since the late 90s, the employers' side in ILO started to attack the right to strike. We don't have communism anymore in Europe, so we can kind of get to these workers and check what kind of rights they should have, and they shouldn't have the right to strike. So first what happened was in 2012, the side of employers boycotted the ILO. So the ILO is tripartite organization, employers, trade unions, and governments. And for 3 years, employers boycotted International Labour Organization, claiming that ILO conventions don't state explicit right to strike, so there is no internationally recognized right to strike of workers, and there shouldn't be. And this 3-year boycott was faced with protests, especially in Europe, quite big protests. There was also a lot of publicity and a lot of academia and intellectuals engagement and strikes in some Western European countries. So the employers agreed to sign temporary statement that we recognize that conventions might be interpreted in the way that there is international recognized right to strike. Excuse me. But as scholars and activists, union activists say, it ain't over till it's over, because it's only temporary suspension, as we know, and that the employer's side will try to boycott or stop interpretations on the right to strike in international courts, and they are doing that. Cases in ILO since 2015 are blocked. Cases of different countries are blocked by the employer's side. They do not agree to confirm violations of the right to strike in different countries on the international conference. But because they kind of lost on the grounds of International Labour Conference, what they did, they tried European Court of Justice, and this, in my opinion, was successful for employers. The court cases from the second decade of 21st century, known as Laval Quartet, are court cases of 4 European companies where the European Court of Justice had to decide whether the freedom of movement, freedom of trade in Europe is more important than the freedom to associate and freedom to strike. And especially in those 2 first cases, Laval and Viking, those were cases explicitly about striking because of employing employees from other countries, because of the localization of employees, because of the localization of capital. And what the court said, it said 2 important things. The right to association, the right to strike is human right. It's very important, and it cannot be diminished by the treaties of freedom of movement and treaties on freedom of trade. But national courts are obliged to investigate. They can investigate whether strikes are justifiable and proportionate. So whether the strike action is not the exceed mean, whether there were other means than strike. So the European Court of Justice kind of recommended for national courts to discuss the right to strike of workers, checking the demands, checking the effect that the strike will have on economy, on society, and decide, and national courts can decide whether strike is proportionate and good mean or proper mean. And what happened, we can see, those are just examples, that in Europe, on the grounds of justifiable means, proportionate means, or minimal service means, so holding minimal important social services, courts in different countries are banning strikes, and especially in past 2 years, starting to ban them more and more often. In case of Norway and Finland, I think it is also government that took these decisions. It's not only courts, but also governmental decision that workers have to go back to work. And as you can see, okay, those are mostly public enterprises or public services, but international law and international courts always said that you cannot ban the whole sector and whole workers, but this is what we are facing now in many European countries, that the governments and courts force people to go back to work or ban strike before the strike for all the sector and all the workers. So this is what's happening now. And I wanted to look for a few minutes on our region and on the changing economy in our region, and then show you how in Poland, in those periods, the right to strike changed, and probably you can relate. So in Poland, until 1982, strikes were totally banned. They were criminal, anti-revolutionary activity. Of course they happened, and they were mass strikes in Poland in 56, in the 60s, and the 70s, and in the 1980s. And in the 1980 mass strikes, with the demand of legalization, free trade unions, and freedom to strike, we had martial law introduced. for over 2 years, but during this time, a work on a new law of associations and of strikes started, and in 1882, strikes became legalized. But they became legalized in such a manner that legal strikes still were impossible. So this is important to remember that the first legalization was in 82, but the construction of the law was such that it was almost impossible to organize legal strikes. So the mass strikes that happened in late 80s and early 90s were usually illegal strikes. Then, after the change of the system, solidarity intellectuals and solidarity elite became members of parliament. Solidarity became almost a political party and was present in parliament. And in 1991, new law on workers' associations and right to strike was introduced. I will get to a detail in a minute. This law hasn't changed till today, but through another proceeding waves of accumulation, changing economy, the right to strike was further and further restricted. This is the socialist state era law, the new procedure that legalized strike, introduced 5-stage collective dispute procedure with mandatory negotiations, mandatory conciliation, mandatory arbitration, and strike. There was no ballot back then, but strikes became assigned to a workplace. This is very important that political strikes were banned totally, like it was stated in law, and strikes and collective disputes started to be assigned to our workplace. Still, workplaces were huge, 20,000 people, 15,000 people, 30,000 people, but it was assigned to a workplace. Now we have much smaller workplaces in Poland, so it's even harder. So the demand of the roundtable negotiations that we had in 1989, 1990, so the negotiations between democratic opposition and socialist state, one of the biggest demands was to legalize trade union solidarity and to introduce real right to strike in Poland. We came to the new economy with mass strikes and with two projects of the right to strike. One was the author of the first one was Solidarity, and it was kind of liberal proposition. No ballot, no referendum, no additional stages, just negotiations. Explicitly, there was freedom to strike, not the right to strike. It was assigned to workers, not trade unions. Kind of liberal, and for today's Central and Eastern European standards, very good striking laws. And there was a Senate proposition, so members of the Senate prepared different proposition. And during that time, we faced huge ideological offensive on workers, on socialism, on any social ideas. And who decided on this right to strike? Members of parliament, whom half of were former members of Solidarity, but they were elites. There were country elites, there were doctors, there were intellectuals, there were lawyers. And what happened, the Senate proposition won, and Solidarity members of parliament threw to garbage their own proposition that was very liberal, and they supported the proposition of Senate. Why? Because they knew how strikes are dangerous for the economy and political system. Knowing that you can throw whole political system and you can defend whole political system and political ruling class with strikes, now introducing new system, market capitalism, they knew how strikes would be dangerous, and the whole debate in the parliament was we need to stop strikes because we won't be able to introduce market economy. So this ideological shift prevailed, and this is the law that we have now in Poland. So in terms of mandatory stages, the number is the same. We have 2 non-mandatory stages. Arbitration is not used. Conciliation court, it's arbitration court. It's not used in Poland whatsoever. But we have still 5 mandatory stages. 2 are of indefined time. There is no time limit for them. And also there's referendum, so ballot. As you can see, the procedure is very complicated. First of all, there is a short catalog of demands. And because of this short catalog of demands, branch strikes and general strikes are impossible in Poland because the demands have to be targeted towards your own employer. So you cannot demand higher pensions for elderly. You cannot demand rising minimum wage because it's something of this outside of the scope of expertise of your employer. So you cannot demand it by strikes. And demands can only concern workplace. And it's also only unions can start this procedure. There is no possibility for workers' representative or workers' collective to start collective dispute procedure. 2 very important steps, mandatory negotiations and mediations. What is demanded there is the protocol of disparity. If you still disagree, you need to sign protocol of disagreement. Employees use it to prolong negotiations, to prolong mediations, because they say, I won't sign the protocol of disagreement because I still want to agree. Let's talk more. So this whole procedure takes, as also our colleague from Lithuania said, 3 years, 2 years. It's very tricky to form your demands when you know that the whole procedure will take 3 years. You always have to wonder about inflation and, of course, about the turnout of workers, because those who worked 3 years ago might not be here anymore. Of course, we have referendum with 50% of attendance and additional 50% vote. The challenges that it imposes is first referendum. As you can see on the example of coal mine, the union has to organize voting, which is basically something like local elections, and it's from their own money. Because if 18 or 19,000 of people vote, it costs a lot of money. You need to produce those referendum cards, you need to organize this referendum. This is very expensive and prolonged procedure. In coal mine, you can block the gate and tell to your colleagues, vote or you won't go home. And that's how you get attendance, that's how you get turnout. In supermarkets, you cannot do that. I mean, there are 5 employees or 6 employees in one supermarket, but there are 10,000 supermarkets, and they are counted as one workplace. So referendums in supermarkets are almost impossible, and they always fail in Poland, because it's just impossible to make them. In education, each school is different workplace. So when we had referendums, we had 16,000 referendums, and 16,000 mediations, and 16,000 negotiations, and 16,000 protocols. So this is how the strike in 2019 happened, with mass mobilization of the teachers' trade union. And these are numbers of strikes in Poland, and what is funny about this graph is that when you look at it, you might think that in 2008 there was revolution in Poland, in 2019 there was revolution in Poland, the whole country stopped. No, this is problem with statistics. Every strike is counted separately, so every strike in school is counted separately. That's why those are only schools striking, those are only schools striking. Here, hospitals and miners were striking for one day schools. Here there was one-day school strike, but you will see proportions, not many schools took part in it. And only in the 90s we can think about mass strikes because still the workplaces were huge. So one strike was happening in like 20,000 workplaces. Now there are like many strikes, but this is just one branch striking. So keep that in mind. It's very hard to compare procedures, and there are many questions about that because reading legal texts about law in different countries is very hard, and it's very misleading because different papers I've read said different things. We might discuss that later. But the point of this table is just to show you that most Eastern and Central European countries have very long procedures, very similar procedures with many steps to go. What this graph shows, it shows nothing, I mean maybe one thing, that all the Central and Eastern European countries have low numbers of strikes. This is per 1,000 workers to compare, right? Because comparing like 60 million country to a few million countries is hard, so it's per 1,000 workers. So the numbers are very low. Scarcity of data, I mean some countries just don't report to ILO and they don't care, so we don't have data about these countries. We know that behind strikes there is more than law. We know that law really restricts us, but we cannot say that Lithuania and Poland don't strike just because of the law. There's also history, there's also generational change, there's also ideology and incomes and the how fast the minimum wage grows. But of course, favorite example of mine and our colleague that spoke before, France. France has very liberal law. France, only in public sector you need to give notice 5 days before strike. That's it. Outside of public sector, strikes are just freedom of strike and you can do them. What this graph shows, that per 1,000 workers, okay, France has more, but doesn't mean that even with such liberal law, everybody will go on strike, which is often an argument of lawmakers. We cannot let them to have this more liberal right because then the whole economy will stop. France is an example of a country that, yes, has a lot of strikes, but per 1,000 workers, it doesn't stop all the time. People are working, and it's just a tool using in negotiations. And quickly I wanted to show you the changes that happened later after this legislation came to force. So until now we had no major legislation changes, but what happened was precarization and exclusion of workers from the right to associate. So if you can't be member of a union as precarious workers, you also are stripped of the right to strike because you kind of can't even start this procedure because you can't have a union. So that was the late 90s, early 2000s what happened. Further ideological attack on unions in liberal media, I mean with calling people lazy, pigs, using very harsh language. And of course the crisis in trade union membership, because of structural changes that started in Europe, Western Europe, before. Also, after 2008, we had some struggles for the right to strike. Precariat was included in the right to associate in 2019, but it's mostly on paper. So people on civil contracts and self-employed can join unions, but they have no protection, right? So they can participate in strike, but there is no protection of their contract because their contract is civil contract. Public administration, Poland, Solidarity won case in ILO. still the government didn't change the law on ban of strikes in public administration. The ILO says it's too broad and it excludes too many workers. Those are not essential workers. If you work in, I don't know, Office of Agricultural fees or taxes, right? It's not essential services, but still they are stripped of the right to strike. Social welfare workers, because they are public workers, they won only for themselves. Case in court. Healthcare workers won by doctrine. I mean, lawyers, scholars decided that they will interpret the strike law in such a manner that healthcare can strike, but there were voices that they cannot. Because hospitals are public hospitals, so they wanted to extend this public administration ban to hospitals. Teachers, the case is more in the discourse ongoing. Whenever teachers want to go to strike, there are propositions to ban strikes for teachers, and the same is for flight attendants and traffic controllers. And now I want to quickly, for 10 minutes, tell you, maybe 5, about the attack that happened in Poland in courts. Similar attack as in International European Court of Justice, but on the grounds of Polish laws in Polish juridical system. Because the strike law says that for unlawful strike, you are responsible on the grounds of civil law. They are using another case of civil law, totally outside of workers' relations. It's called collateral protection, and it's used usually in divorces. If you have a car and you divorce somebody, the court might say no party can use this car until the divorce will be over, because if somebody uses it, it can crash and there will be no car to divide between the parties. And now the employers are using this collateral protection to ban strikes. You cannot strike before labor court decides whether your referendum, mediation, negotiations were legal, because if you go to strike and then after 2 years the court will decide it was illegal, you will already do the damage. So we need to ban strikes on this basis. And first cases in 2005, the rest cases are from 2008 to 2022, and it was 11 cases, 13 motions, because one company 3 times did the same, during the same procedure. And first instance courts usually ban those strikes. And they usually ban it 1 day before strike, 3 days before strike, because the court gathers in 1 day after employer's motion and decides. And then when the union goes to court, it takes years. So this is first thing that happens. Second, it's only government and local government expertise. Those are all public enterprises or public offices. So never private entity used this kind of procedure, this kind of motion. And those are just some statements of the court, what they prohibited, how they interpreted the law. And as you can see, for example, planned strike 7 November, 4th November, ban on strikes. As a union, you need to go to workers that are ready to go to strike and tell them about the procedure, about the court, they get scared. Appeal court, as you can see, quite early, only 3 months, 2 months, so it was very quick. Another example, if they ban any actions that will disturb handling and shipping coal, they actually banning strike, right? Because not working also disturbs handling of coal, so those are court's argument. And of course we have cases that explicitly ban causing losses to the company, which is the core idea of strike, is causing losses to company. And you cannot strike without causing losses to company. And what I would like to point out, that this is very unlogical ruling, because they say that if you will strike for 1 week, the company will lose, for example, 10 million euros. But who says we will strike for 1 week? We can strike for 1 hour, right? It's the employer's decision how long we will strike, because if you will sit with us and talk to us, the strike will end in 1 hour. So how can court count when strike will end? And this is very dramatic case. We had those miners with sleeping bags, with vitamins. There was underground strike. They striked for 17 days. The police used those rubber bullets against families supporting and colleagues supporting the strike. And the court stopped the strike after 17 days, saying that the strike is causing too much loss to the company. Because of that strike ruling, that the losses to the company are too big, the unions agreed to very shitty agreement with the coal mine owners. They agreed to work on Sundays to make up for the losses for the strike for next 2 years. And the last case I wanted to show you is the Polish Airlines strike. 3 times during the same dispute, court banned strike. 3 times it was announced, like planned strike, 28th of September, 25th, court ban. Planned strike, May 1st, court ban, 27th of April. The same happened in October, but because the leader of the union was fired, then you can start a strike without procedure. And this is what they used. 60-something employees started the strike, and the second day of strike, they were all dismissed. So this is first day of strike, everybody in their uniforms, very, elegant strike. The stewardesses had high heels on strike, and from the day 3 to 14, they were just striking in front of the Lot Polish Airline headquarters. It was November. We had, this horizontal rain that you cannot hide from. People from squads were making soups for them, supporting. So this is how the strike looked. The strike was won because they were all fired, but they decided to come every day in front of the headquarters, and it was very, spectacular for the media, and they got a lot of support from society. They won. The leader was reinstalled to work, and also they signed some wage agreement. Not as much as they demanded, but still, and everybody got back to work. This is just, I wanted to show you as our practice as a union, because as a scholar and a unionist, we try to put our research into practice. So what you saw is my PhD research. And based on this PhD research, I wrote the chapter 3, A Strategic Approach to Industrial Action. And the rest is Kuba and our lawyer Michał. We wrote a book that manual for trade unions is in Polish, but it's online free. And we will start to promote it in our union this November. So this is just example I want to show off that we are trying to kind of give back to the union what we know and put it into more not very scholarly language and use it to our advantage as unions. And 2 last things. As Workers' Initiative, we try to use different tactics to go around this law. One of them was online referendum, because Amazon has now, I think, 7 or 8 warehouses with 40,000 or 50,000 employees. The referendum in Amazon was almost impossible to do on paper, because also they throw us out from the warehouses. They don't let the referendum to go in the canteen. So the referendum is done on the street, on public pavement, but still you need 50%. So the referendum was ongoing. It lasted for months, which also will be disputed in court. Was it legal to hold it not for 1 day or 3 days, but for months? But also they tried to do online referendum. They had application written by, like, you know, leftist programmers, very secure. People use their PESEL, social security number and batch number to double verify. Sad face, still, we didn't get 50%. Majority voted for strike, but we didn't get 50%. This is the mostly complicated thing to do in Poland in big companies, to get 50%. If you get 50%, you can be sure that almost everybody voted for strike. But just to get this. And second protest I want to show you is daycare. Daycares have problem with strikes because it's local government, so they are included in this public administration ban. Second, they have this moral aspect, especially with children under 2, like how can you strike and leave the mothers with no support, and you cannot abandon. And also there's a problem who's the employer, because each daycare has director or principal, but actually the employer is the local government. But you cannot have demands to local government because you have to have demands only to the direct employer who signs your contract. So there were like obstacles how to strike, and what they did, they didn't strike, they blocked the city. They went out to Poznań city, they sat on the tram tracks, trams couldn't go around the city, so it got very much of media attention, but also it blocked public services. So for public services, if your produce in capitalism towards society is public services, how can you strike? You can disturb your own or others' public services. So this was this method. We won't disturb our public service because it's childcare, but we will disturb other public service that is less essential or less harmful, but still very kind of disturbing for the society, that was public transport. And they've managed to reach agreement with local government on rises of the wages. To sum up, we will look how it will develop. There is this what I call juridical climate, with changing of economy and also with education of new generations of lawyers. There is mindset changes, and in my opinion, when we had old judges that still remembered and were working during state socialism, we had more pro-working class rulings than we have nowadays, because also academia, ideological change, and in my opinion, lawyers also changed their mindset, those lawyers who become judges then. We see that employers, because they see how long the cases in court take, they use locals. They use locals and they use firing as repression. We have cases in Poland that took 7 years, our record, to reinstall our activists to the workplace. Solidarity in one automotive factory, car factory, has an activist who's been fired 3rd time in a row. So this court reinstalls him after 2 years. He goes first day, he is fired again, and so 6 years now he was fired for the 3rd time. As I said, and Kuba was talking yesterday, we use work rule, we use safety measures to slow our work down, to make it, to kind of go around strike law. We go to courts, and there are specialized law companies now that specialize in union busting, and we receive in every local, in every workplace, from the letters from the same legal company with huge capital. So it's killing us. It's really taking a lot of resources, both financial and intellectual. The effects of this changing fix, institutional fix that is happening now is recommodification of collective dispute, of labor, treating labor as commodity, as something you can debate on in civil court, in private law, and this is also sign of growing authoritarianism of governments, because public companies take the most actions against trade unions, against strikes. And what we are now promoting in Workers' Initiative is to turn it around. Let's stop talking about the right to strike and proving that we have right, proving by negotiating, proving by mediation, by documents, and showing in court. Let's start talking about the freedom to strike. So the freedom of every person to stop work and to change the mindset, at least discourse, about the law, because if we have a freedom to association, we also have a freedom to strike, like any other freedoms of humans and workers, not the right that you have to prove and that you have to go through a long procedure to get one. Thank you.